Hi guys, in today's video we're going to discuss agency. Let's start by discussing the formation of an agency and the definition of an agency, which is a consensual relationship where one party, the principal, grants authority to another party, the agent, to act on his behalf and under his control with third parties. So control is a fundamental element of the agency definition. The acts of the agent will be binding on his principal. So for the formation of an agency relationship, there are three possibilities. By agreement, and consideration is not needed. Writing is generally not needed unless the equal dignity rule applies. The equal dignity rule provides that if the contract that the agent is going to sign is within the statute of frauds, then also the agency agreement has to be in writing, unless there is detrimental reliance by the third party induced by a manifestation made by the principal. We also need to discuss the capacity of the parties in the agency agreement. For the principal, we need personal capacity, which means that minors and incompetents cannot be principals. But for agents, only minimal capacity is required, so minors could be principals. Another possibility to form an agency relationship is by operation of law. And here we are really talking of two possibilities. The first one is by estoppel, which is apparent authority that we will discuss in the next slides. And the second one is by statute. For example, statutes appoint the Secretary of State as an out-of-court state motorist agent for the service of process. The last method to create an agency relationship is by ratification. So the authority is conferred by the principal after the agent has already entered into the contract. Let's move on now to discuss authority. Authority can be actual authority, either express or implied. We have express authority when the principal expressly authorizes the agent with written or spoken words to enter into a contract. We have implied authority when the authorization is inferred from conduct or circumstance. There are three possibilities under implied authority. By necessity, so implied authority to do all tasks necessary to accomplish expressly authorized tasks. So if the agency is to purchase something, then the agent has also the authority to pay and to accept delivery of the goods. Actually, implied authority can also be by custom. Implied authority to do all the tasks that are customarily performed by persons with the agent's title. A third possibility is by prior dealings. So implied authority to do all tasks that the agent believes are authorized based on prior dealings with the principal. Another possibility is apparent authority. Here we have a two-part test. First, we need some actions by the principal that create a reasonable belief in the mind of a third party that the agent had authority. And number two, we need reliance by the third parties. One example of apparent authority is the example of impostors, where a principal negligently permits an impostor to appear to have authority. In that case, the principal will be liable for actions undertaken with such authority. Finally, authority can be acquired by ratification. Here the authority is conferred by the principal after the agent has already entered into the contract. In these cases, the agent purports to act on behalf of the principal despite the fact that the agent does not have authority to do so. But the principal subsequently ratifies the transaction. Now let's move on to liabilities. We will discuss the liabilities of the principal first. So liabilities can arise out of torts. We need to apply the doctrine of respondeat superior, where the principal will be held responsible for the agent's torts if we have the following elements. Number one, the tort was within the job description, the tort was on the job, and the conduct was intended for the principal's benefit. If we have these three elements, then the principal will be liable for torts committed by the agent. Regarding intentional torts, generally there is no principal liability unless the acts are specifically authorized by the principal, they are in the nature of employment, or they were motivated by the desire to serve the employer. Regarding sub-agents and regarding borrowed agents, there's generally no liability unless there is control by the principal. So if the principal retains control of sub-agents and borrowed agents, then there is liability for the agent's actions. For the independent contractors, there's no liability unless one of the following exceptions apply. Extremely dangerous activities, estoppel, which is the situation where a principal holds out an independent contractor with the appearance of the agency to third parties. Negligent hiring or supervising. Finally, non-delegable duties. Now let's discuss contract liabilities. Here, the rule is pretty straightforward. If there is authority, then the principal is going to be liable. Now let's discuss the agent's liability. The agent is liable if the contract was unauthorized, and the principal is going to be liable if the contract was authorized. However, if the principal was undisclosed or partially disclosed, then the principal and the agent will both be liable. Now let's move on to discuss the fiduciary duties in the agency relationship. So the agency is a fiduciary relationship, which means that the agent and the principal owe each other fiduciary duties. Let's start by discussing the principal's duties. The duties created by contract, the duty to reasonably compensate the agent, the duty to indemnify the agent for the expenses, the duty to cooperate with the agent, while the agent has the duty of care, duty to obey reasonable instructions given by the principal, the duty of loyalty, which encompasses the following situation. The agent cannot engage in self-dealing transactions, usurping principal's opportunities, and the agent cannot receive secret profits. The agent's duties are also the partner's duty in general partnerships and other partnerships, because the partners are partnerships agents. Let's move on now to our final topic in the agency relationship discussion, which is the termination of the agency. An agency can be terminated by the following. Number one, lapse of time, which can be specified in the contract or in the absence of specification, reasonable time. Occurrence of a specified event, specified in the contract, of course. Destruction of the subject matter. Agent's breach of fiduciary duty. Unilateral termination by either party. Death of either party. And here it's a cause of termination unless we have durable power of attorney, or incapacity of either party unless there is durable power of attorney. Alright, thank you for watching. Don't forget to subscribe and watch my other videos on US law. Bye everyone.